I call the meeting to order. Chers collègues, bienvenue à tous.
Dear colleagues, welcome to all of you, and I wish you a good year. Happy New Year.
91 of the House of Commons Standing Committee on Justice and Human Rights. Happy New Year to everyone, and I have no doubt that we will continue in 2024 with the same collegiality and respect atmosphere that we are used to in this committee, so thank you for that. We're here today to discuss the request for an emergency meeting pursuant to Standing Order 106, Sub 4. The meeting is taking place in a hybrid format pursuant to the standing orders. Members are attending in person in the room and remotely using the Zoom application. We have 2 members on Zoom. And I believe, since there are no witnesses outside, the members, you're all very well versed in the rules in terms of how you are supposed to use the Zoom application. Simply to say that tous les tests sonores ont été effectués.
All the sound tests have been carried out successfully.
There's no issue with the sound from those attending in Zoom. So, colleague, we have circulated 106 Sub 4 meeting request received by the clerk on Friday afternoon. This request is pertaining to judicial vacancies, and so we are here to discuss the subject. And I will open up the floor. Mr. Moore.
Thank you, Madam Chair. And,
Madame la Présidente.
Madam Chair, a call to order before we get to going. I, too, am concerned about 2024. I express this to all members of the committee and to our staff. That said, I understand that we have 2 members by Zoom. Have the tests been carried out, and are they conclusive? I'm just going back to my usual modes. I'm sorry, but I'm strong on this. Mr. Fortin. Yes. As I said a little earlier, both in French and in English, the tests have been carried out. I'm sorry, I was a little distracted. Thank you very much for asking, though. And now we will begin with Mr. Moore.
Thank you, Madam Chair. The reason why we have asked for this meeting is that, as all of us are aware, former Minister Lametti had made some remarks recently about the judicial appointments process. And all of us around this table, over a number of studies and bills, have heard commentary about, I'm thinking even about the study we did on the federal government's obligation to victims of crime. We've heard about the need to fill judicial vacancies. And the former minister made comments about judicial vacancies, about the appointments process, and it sounded like his frustration in filling those vacancies. So in an effort to get some answers on that, those that had signed, had asked for this 106.4 meeting, a special meeting, so that the committee members could hear from witnesses on this issue and could act accordingly. So I want to move a motion, Madam Chair, related to this proposed study. I think it's being circulated, or it's been circulated. It says, given that the former Minister of Justice, David Lametti, blamed for the slowdown of judicial appointments solely on the Prime Minister's office, and last May, Chief Justice of the Supreme Court Richard Wagner wrote the Prime Minister expressing, quote, great concern about the shortage of judges in the country, that the committee immediately launch a 4-meeting study in order to assess the impact of the insufficient number of judges Canada has, and calls the following witnesses: Minister of Justice Arif Virani, former Minister of Justice David Lametti, Commissioner for Federal Judicial Affairs, and Chief Justice Richard Wagner. That would, of course, be a starting point. Other parties, of course, would have their idea for witnesses, but I do move that motion, Madam Chair, and appreciate the committee's consideration of this important topic.
You only have the motion in English?
Yes.
Mr. Moore, I'm informed by the clerk the motion is only available in English. What happened to the French version?
Madam Chair, I understand that the French version is on its way, so, yeah, should be with the clerk shortly.
Madame la Présidente,
Monsieur Fortin, oui.
avec
Madam Chair, Mr. Fortin, yes. With your permission, then, I suggest that we suspend this meeting for a few minutes just to allow a little time to receive the French version. I think this will be the best approach. Thank you, Madam.
Merci.
Yes, indeed. Thank you.
Merci beaucoup. Je pense
Thank you very much. I think that everyone now has a copy of the French version as well of the motion.
now have both English and French versions. We will continue where we started off. I believe Mr. Moore had a motion on the floor.
Yes.
Point of order,
and
Madam Chair?
Yeah. Sorry, Mr. Housefather. Yes, I will. Look at the camera from now on. So
I was just
I'm glad
wondering,
you
Madam
mentioned.
Chair, if-
Thank you. Yes.
I was just wondering, Madam Chair, if you would kindly
Oh, he didn't
circulate
get
it to
it.
us by email, the motions in
So-
English and French?
Yes, Mr. Clerk. Yes. Thank you. One moment. Let's make sure that the colleagues on virtual also have it. Okay, je pense que c'est fait, Monsieur House.
Very well. I think it has been sent out, Mr. Housefather. Have you received a copy? Thank you so much.
Were you continuing or yes?
Thank you, Madam Chair, and thank you to everyone for your consideration of the motion. I think it is important that this committee, this is fully in our wheelhouse, that we would study this issue. It's a big issue. I'm not proposing, I'm not proposing that we spend an inordinate amount of time on it. I think we should, but we should take a look at the impact of these vacancies on our justice system. Two, I don't see this in any way necessitating any delay in our consideration on Bill C-40. We have Thursday's meeting. We could possibly deal with C-40 at that point. But I do think it's something that we should take a look at for the reasons that are in the motion itself. And thank you for your consideration.
Yes, Monsieur Maloney.
Thank you, Madam Chair. Just want to follow up on Mr. Moore. First of all, welcome back, everybody. Happy New Year. It's good to see everybody. And I hope this committee can get off on the right foot and get moving forward on important issues at hand, which is not how I would characterize this motion if I was asked, to be frank. Look, first, I would just start by saying thank you to former Member of Parliament and Justice Minister Lametti. As we all know, he's announced that he's decided to retire and move on to private practice. In my view, and I know this view is shared by people certainly on this side of the table, and I believe around the House, he was a remarkable Member of Parliament, and he served as the Minister of Justice with integrity and honor, and I was very proud to work with him, and I have nothing but total admiration for the work he's done. So I just want to say thank you to him. Look, this motion, one of the many problems with this motion is every time you have a discussion like this, it somehow impugns the integrity of the justice system. I'm looking across the table at 5 lawyers and one person who had the wisdom not to become a lawyer. It sends a wrong message to the general public, because I think everybody who has practice will agree that Canada has one of the greatest judicial systems. It's the envy of the world. I'm very proud to be part of it. Justice Lametti has as I said, a great track record as Justice Minister, including judicial appointments. I'm very proud when I look at the people who have been appointed under Justice Lametti's watch and the people who have been appointed under our current Minister of Justice's watch. It's a source of pride, frankly, because they are quality people. But the process by which they're appointed is something that I'm also very proud of, because if you look back over the past 7 years, and you look at the number of women, for example, that have been appointed to the bench since 2016, it's over 50%. That's the first time in Canadian history we've ever seen that. The bench now is more reflective of society as a whole, something we should all be very proud of, all while maintaining the integrity and quality of our system. So to proceed with this motion would be unfortunate because it can only lead to a discussion which becomes political, and as I said at the outset, sends the wrong message to the general public about why we're having this discussion, because it raises questions that aren't real, that maybe that we do have a problem when we don't. And just to address Mr. Moore's other point about legislation, we've been patiently, as a committee, trying to deal with Bill C-40. We left here in December after, not several days, but several weeks of filibustering, delaying the passage of that bill. We are so close to having it done. There are families and people across this country who are watching us and who have respect for the integrity of our system. And if we waste time on this motion and delay dealing with C-40 any further, it will be a complete shame, and it's a display of total lack of respect for all of those who are waiting patiently. So I will be voting against this motion in the hope that we can move on very quickly to get back to Bill C-40. And I should point out, too, that in the last 12 months, there's been 100 judicial appointments filled, and in keeping with that accelerated pace, and this meeting started at 11 o'clock. There's been 8 appointments made since we sat down here this morning. Thank you, Madam Chair.
All questions and answers, please, are to be directed through the chair. Much appreciation. I will now go to Mr. Brock, followed by Mr. Van Popta, Mr. Caputo, Monsieur Fortin.
Thank you, Madam Chair. With all due respect to my Liberal colleagues, and in particular my friend Mr. Maloney, I don't share his analysis of the importance of this study. This is not a political opportunity to gain points. This is an opportunity to improve access to justice. Every Canadian has an absolute right to receive timely justice, whether that be in the criminal realm or the civil realm. And we're all lawyers, and I can just anecdotally share with you that this issue of the lack of urgency in judicial appointments is a chronic, serious issue that is undermining the functioning of our judicial system. So much so that the Chief Justice of the Supreme Court of Canada had to cry out and make public his real deep concerns at the pace that the federal government is appointing justices. Where I will agree with Mr. Maloney is that after the appointment of our new Justice Minister and the Attorney General, there has been a sense of urgency in his office. He has appointed far more in the time that he has held that office than in the 4 years previously occupied by David Lametti. David Lametti, in a CBC News report, said essentially, not my problem. I wanted to appoint. I was hamstrung by the PMO's office. Now, the process is very clear. Under the current judicial appointment process, the Justice Minister is responsible for recommending a candidate for approval. There are 3 aspects to that analysis: highly recommend, recommend, or do not recommend. Justice Minister recommends a particular candidate for approval following a due diligence process overseen in part by the Prime Minister's office. So he was accurate to say that it wasn't strictly his decision and his lack of a sense of urgency. He was stymied, essentially, by the lack of urgency in the Prime Minister's office. And that should send a very serious, alarming signal to all Canadians and to all members of the judicial process. Now, Mr. Maloney says, well, in the last week alone, we've appointed X amount of justices, and today, 8 justices. That's great. I haven't seen the news. I haven't seen the reports. I'm not going to doubt the authenticity of what my friend had to say. But I can tell you that 6 months ago, when Justice Wagner cried out for assistance and had a personal one-on-one telephone call with the Prime Minister, there were 79 vacancies. As of January the 1st, and anyone can do a Google search through the Office of the Commissioner for Federal Judicial Affairs Canada, across this country, as of January the 1st of 2024, there were 78 vacancies. So, but for the comments of Mr. Maloney, we've improved on the stats by 1 justice. Because inevitably, the justices that often are considered for federal judicial appointments tend to be senior members of the bar. There are mandatory requirements for retirement. There is options for federal justices to change their status from fully engaged or fully active justices on the bench to supernumerary status, which means they only sit a very limited amount of time per year. But every year, cyclically, we have a number of justices moving into new categories or flat out retiring. The numbers are always increasing. So the fact that we've got 8 new appointments today, that's great. Come February the 1st, we could be 12 down. So the problem does not go away. This problem of not completing a full complement of federal court justices has existed for decades. Ever since I've been a lawyer, there has never been enough justices. And when you don't have enough justices, your access to justice is denied. So much so that the Senate, 2016, produced a study called Delaying Justice is Denying Justice from August 2016. And one of the recommendations is to appoint more judges on a timely matter. Here we are, 8 years later, still arguing that the appointment process is not efficient, that it often takes 8 months to a year, if not longer, to appoint justices on the bench, and the impacts are profound. Now, I've quoted you what Justice Wagner, or actually I haven't quoted what Justice Wagner had to say. I might take this opportunity to do that right now, because I think his words are very telling. Judicial vacancies are having, as Canada's Chief Justice sounded the alarm over the serious consequences of judicial vacancies, he said in a wrap-up, he's highly critical of the current pace of judicial appointments, warning that languishing vacancies on courts across Canada are exacerbating an already alarming situation. The empty positions have a significant impact on the administration of justice, the functioning of our courts, and access to justice for the public. It has major effects in every province of the country. According to Justice Wagner, there are suitable candidates available in every province and territory. So there's no reason why these vacancies cannot be filled. As noted by Justice Wagner, subcourts have been operating for years with vacancy rates of 10 to 15%. He said it's not unusual to see some positions remain vacant for months or in some cases years. This, even though in most cases, this is quite telling, Madam Chair, when judges retire, they give 6 months' notice to their respective Chief Justice of their province. This isn't an abrupt decision, I'm going to retire next week. There is a process, 6 months process for vacancies to be filled, but it's not happening. I pulled another article from a civil litigator in Toronto by the name of Catherine Marshall, and she wrote an op-ed in one of our papers not too long ago, and the title is, "Our Judicial System is Broken, but Politicians Don't Seem to Care." Well, I can tell you, this politician certainly cares. The entire Conservative bench certainly cares, which is why we brought this motion. She indicated there was a particular victim from an Ontario town who was scheduled to testify against her alleged rapist past summer. But when she turned up for her day in court, she was told her case couldn't proceed because there was no courtroom available. She says, talk to any lawyer and they will tell you the horror stories about turning up for day one of a trial only to be told there is no courtroom or judge available. For lawyers, it is frustrating, but for a victim of crime who has mustered the courage to come forward, it is beyond devastating. Now, we all know how our criminal justice system has changed in light of the Supreme Court of Canada decision in R.V. Jordan. Jordan has set a presumptive ceiling by which cases must be completed in the lower courts and in the Superior Court. 18 months in the lower court, 30 months in the higher court. When you don't have judges to fill the courtrooms, you have serious cases, sometimes homicides, serious domestic violence, serious gun offenses, where the judge is ultimately hearing a violation of the right to be tried within a reasonable time, will often conclude that the Crown has not discharged its onus, that there is a charter violation, and that violation results in a withdrawal or dismissal of the charges. Now, what kind of message is this committee sending to victims across this country that you don't matter? We already have a serious issue with domestic victims coming forward because they don't trust our system. We have an opportunity as parliamentarians, particularly in this committee, which should be charged with the responsibility to ensure the timely, efficient delivery of judicial services, both in the criminal and civil field. To turn down this very serious, important, relevant study, in my view, is shameful. Thank you. Those are my comments.
Thank you, Mr. Brock. Mr. Van Popta, please.
Thank you, Madam Chair. I wasn't going to speak on this until Mr. Maloney somehow suggested that the Conservatives putting forward this motion that we should study the government's negligence in appointing judges in a timely fashion. Somehow that brings the administration of justice into disrepute. I would say exactly the opposite. We were just shining a bright light on the negligence of this government and how that negligence is bringing the administration of justice into disrepute. And that's not me speaking. That's not Conservative members of Parliament speaking. That's our Chief Justice Wagner speaking last year at some time. And I would just say that it's very, very remarkable for any judge to go public with concerns like that. And I think that just highlights how serious the matter is. Just have a couple of quotes from a letter, and this is from an unofficial translation into English. Mr. Justice Wagner expresses his grave concerns regarding the significant number of vacancies within the federal judiciary. And he talks about the access to justice and the health of our democratic institutions being in danger. These are very serious allegations. And I think that, of all people, it's the Justice Committee of Parliament that should be very concerned about this, and that's why it's such an important study. I think that we need to go ahead with it. Here's another quote from Mr. Justice Wagner's letter. He says that vacant positions have significant impacts on the administration of justice, the functioning of the courts, and the health of judges. And he says that the impact of vacant positions on judges themselves is also significant. Faced with chronic work overload and increased stress, it is increasingly common to see judges placed on medical leave, which has a domino effect on their colleagues who must carry the additional burden. And I think that this is a very interesting sentence because it relates to my province. If current difficulties continue, it could also become more difficult to attract quality candidates for judgeship. This is already the case in British Columbia. So if anything brings the administration of justice into disrepute, it is a failure of this government time and time again to appoint judges in a timely fashion. My colleague, Mr. Brock, referred to the R versus Jordan case. Mr. Justice Wagner does as well. And he highlights that because of the 30-month requirement to bring cases to trial and conviction or acquittal, a number of cases have just been dismissed. And he says that the Alberta Court of King's Bench reports that more than 22% of pending criminal cases exceed the 30-month time limit, and that 91% of these cases involve serious and violent crimes. That's what's bringing the administration of justice into disrepute. There's current cases pending before the courts right now, and that is in relation to 4 men who have been charged with serious offenses in connection with the blockades at the Coutts border crossing 2 years ago. Those men have not yet been brought to trial. It's 23 months now, only 7 months away from the deadline. And this is what the public members are saying about this, and I'm reading from Calgary Herald over the weekend. The biggest reason for having I think that there was another parade, I would call it, in support of these 4 men who's been charged but not tried yet. He said the biggest reason, other than to live some of the moment, is the fact that there are still 4 men denied bail in remand 712 days stemming from that event. This person goes on to say, we need to focus on the fact that the reality is that our bail system is broken, and for these men and for a crime that has not been proven, they have spent 712 days in remand. Madam Chair, these are members of the public speaking. These are not lawyers. This is the sense that many members of the public have about our criminal justice system, that people are denied the right to speedy trial as defended by Section 11 of the Charter of Rights and Freedoms, which says any person charged with an offense has a right to be tried within a reasonable time. So the Jordan case was a response to that constitutional right, and it is currently being denied to many people. And I would just wrap up with this. We see a track record that this Liberal government has a disregard for people's charter rights and freedoms. And I'm thinking of the recent decision of the federal court by Mr. Justice Richard Mosley, who highlighted the fact that confiscating people's bank accounts was a violation of people's charter rights under Section 8 of the Charter, which gives people everyone has a right to be secured against unreasonable search or seizure. This government disregarded that right, even though it had been pointed out to them during debate in Parliament in connection with the invocation of the Emergencies Act. This government disregarded it, and I'm very happy to see that the federal court has shone a bright light on it, and that's exactly what the Conservative members of this committee are wanting to do now. Thank you.
Thank you very much. I will now move to Mr. Caputo.
Thank you very much, Madam Chair. I'm exceedingly disappointed here today when we look at the Liberal government once again, after 8 years, getting in the way of justice for ordinary Canadians. At the end of the day, there are people that are sitting in bail on remand. There are people who are dealing with the division of significant assets on a marital breakdown. There are people who may have been injured in a serious act of negligence that are not getting their day in court. And that directly falls at the feet of this Liberal government. And yet, here we are today to investigate this. Here's the issue. The Prime Minister's office was meddling in judicial appointments. If there is no reason to study that, then we might as well just pack our bags and get out of here. This from the former Minister of Justice, who was anything but nonpartisan in a number of different facets. And this Liberal government is saying, we don't want to look at this. There is nothing to see here. The question for me, really, we know that the Liberals are going to vote against this. Will the NDP, again, go along in their acts as part of a cover-up coalition and vote with the Liberals to shut this meeting down, or will they do what's right for Canadians? Now, this has to occur in the interest of all Canadians, period, full stop. I'm going to address some of the things that Mr. Maloney said. He talked about the integrity of the system. You want integrity of the system? Let's look at that. The integrity of the system is brought into disrepute when the Prime Minister's office isn't appointing judges when judges need to be appointed and they're recommended to be appointed. I can't think of anything that would have equal as an impact on the administration of justice from a judicial oversight and from actually administering the justice. Mr. Maloney also says this is a political discussion. Well, tell that to the people who are waiting in remand for trial. Tell that to the people that are waiting for a judge in family court and have 2 or 3 or 4 trial dates canceled. Tell that to the person that was rear-ended 8 years ago and has a traumatic brain injury and is waiting for their settlement. I don't think they would think this is a political discussion. He says Bill C-40 is an issue here. Well, I can dispel that right here, right now. We're saying we'll study C-40 on Thursday. We're talking about today having meetings. C-40 will be done on Thursday. I promise you that. So this idea that C-40 should get in the way of Canadians getting to the truth, in my view, is unfounded. Now let's see what the NDP does. Thank you.
Monsieur Fortin, la parole est à vous.
Mr. Fortin, you have the floor. Thank you, Madam Chair. Well, Madam Chair, I join my voice. I am of the same opinion as my colleagues, Conservative colleagues. I think that we should go ahead with this study. I was reading the article about Chief Justice Wagner's letter of the 3rd of May last. This is quite considerable. The Chief Justice of Canada writing to the Prime Minister to the effect that the situation has become catastrophic. What I write here is that the government has been inert, not filling positions, and their lack of explanation for this delay is very concerning. This was in the month of May. I think there were 25 vacant positions at the time. I've just drawn up the figures. On the 1st of January of this year, there were 79 empty positions on the bench. I, too, have a good deal of respect for Mr. Lametti, whom I believe did his best as Minister of Justice. I am not close to the inner circles of government, so I'm not well positioned to know who is in charge or responsible for what in all details. But from what I can see, the only people who can be held responsible for this problem are indeed the Minister of Justice and the Prime Minister. I have worked on this file in the past, as you know, Madam Chair, over a number of years. And in 2020, I brought forward a motion to this committee requesting a study of the appointment process so that we could determine what the issue was. Unfortunately, we did not go forward with that. So when I see this new request made by the Conservatives this time to address this issue, I feel compelled to accept their reasoning. I think that they are right, and I'm fully convinced that our Liberal colleagues agree as well. Will they vote for the motion? That's another matter. There are a number of considerations, of course, which come into play. That said, I know no legal expert across the entirety of Quebec, and I'm convinced that this holds for the rest of Canada as well, who does not find it of the highest importance to ensure that judges be appointed to the bench in good time. This is obvious. Our confidence in our legal system, as Mr. Maloney has said, and I agree, is an essential factor of our system. And I think that we are, to some extent, responsible for ensuring that that confidence is upheld and assured for all Canadians here in Parliament. I have a good deal of respect for Mr. Lametti. I have no trouble repeating that. I'm not blaming Mr. Lametti, and I have full respect for the Chief Justice Wagner, who is carrying out exceptional work at the Supreme Court. But when I hear that these two respectable professionals, whom I do indeed respect, say, look, folks, there's a problem. We've got to do something about it. When I see Chief Justice Wagner stating that this might degenerate, that this is affecting the Canadians' confidence in their judicial system, I say, well, we can't just sit back and do nothing. Does Mr. Trudeau have good explanations to share with us? From his point of view as Prime Minister, perhaps he does. We'll see. But I think that our work consists of asking him for an explanation, asking him to explain why these positions are still unfilled, and why, since the letter of the 3rd of May, there are still 79 positions unfilled on the 20th of January. I think we need to hear witnesses on this matter in order to understand what's going on. And perhaps send a clear message to the Prime Minister's office to the effect that, look, this has got to be solved. Enough is enough. We can't just sit around noting, all of us, that there's a problem and do nothing about it. I've heard about situations in the halls of justice, in the courts, courtrooms, and same in Quebec, I can tell you. Same as what of my colleagues here have already pointed out about other parts of the country, because there's no clerk, there's no room, there's no judge. Of course, part of this falls to the provinces, the administration of justice, but federally administered administration covers the appointment of judges. That's what's the responsibility at the federal level, and I think that it is our duty to call for more information about the situation. So I intend to support this motion put forward by my Conservative friends, and further than that, I would like to suggest an amendment as follows, that at the end of the 5th line, we call for 5 meetings to assess the impact of the insufficient number of judges, and I would add to also study the appointment procedures currently used and in place, and what that impact is. Well, it'll be interesting to hear about it. We all feel that the impact is quite dramatic, no question about that. But over and above the impact of the insufficient number of judges Canada has, I think that there is a process that's been up and running for a number of years, and I think that's what we should study. That's my amendment then. And the second amendment as well, Madam Chair, that we also call as witness the Prime Minister. Yes, Clerk. Just a moment, sir.
C'est pas possible.
It isn't possible to put in 2 amendments at once. 1 amendment, please. But of course, in a single amendment, you can add a number of items. All right, the amendment I was reading earlier, perhaps I didn't put it correctly, and I agree with you. I understand that point. I understand what the issue is there. But look, the amendment is to add that we have already measured or assessed the impact of the insufficient number of judges Canada has, and I would like to add, so we should study the appointment process that is used and why it is so slow. And that we call the following witnesses, the names that appear here, but to add the name of the Prime Minister, the same amendment, really within the same amendment. The former Minister of Justice Lametti says that the appointments were stymied at the Prime Minister's office level. So I think that if we want to study this process, I think we should hear from the Prime Minister. Of course, he may well say that he's not sort of doing this in the office. Someone else is taking care of it, but that's very fine. We could hear that person. But I think the person who is called to account by Parliament is the Prime Minister in this situation. And, of course, the Minister of Justice. We should hear them both in order to assess and study the current process, how these appointments are made and why they're being made so slowly. Thank you, Madam Chair.
Point of order?
Yes, point of order.
Can we have the amendment in writing? I was getting confused at what was explaining the amendment and what was the amendment, and I couldn't quite follow it. So if I could see it in writing, it would help.
So we're going to translate it as well in English, and the clerk will circulate it. So let's suspend for a moment. I know, Mr. Maloney, you're next on my list. resume, everybody should have received by email the amendment in both languages. Mr. What was his last name? No, Angus. Mr. Angus, have you received it as well? Check your, oh, maybe Mr. Angus is not on the, probably went to Randall.
I will do that in a second.
Okay, he got it, he got it. Okay, we'll continue now with our list, and Mr. Maloney. We've got the amendment, and we've got the main motion.
Yeah, thank you, Madam Chair. Look, my comments on the amendment are pretty much the same as what I was going to say, and I wasn't going to speak again either, Mr. Van Popta, until I heard some of the comments from that side of the table. So, being a lawyer, I feel compelled to respond and set the record straight. Look, if this amendment, I said at the outset, this is a politically charged motion. If I wasn't right before, I am now, because the amendment makes it clear that it's political. It can be interpreted no other way. So I'm going to address a number of points that my colleagues across the way have made. I think it was Mr. Caputo said, it's remarkable that a judge goes public, or maybe it was Mr. Van Popta, to speak about judicial appointments. There's really nothing remarkable about it at all. I attended the opening of the court ceremony in Toronto for many, many years, and the Chief Justice, was a standard line in their speech, even prior to 2015, which was because that's when I was going, was that there's X number of vacancies in the province of Ontario, and the government of the day needs to make sure these are filled. This is nothing more than judges reminding politicians of all stripes of the importance of making judicial appointments and making sure they're current. There's nothing new under the sun about that. So there's really nothing remarkable about that at all. Mr. Brock talked about, supernumerary judges. I mean, yes, there's 6 months notice going that they provide when they're going to go supernumerary, but something that the general public might not understand is that when a judge goes supernumerary, he or she continues to serve as a Superior Court judge in that province, but sitting less weeks, and it's about 50% of the time. So if you were to do the math and a number of people go supernumerary and those people are replaced, you've actually got more judicial capacity than you did before. And in terms of the number going from, he quoted the number going from 100 to 79 currently, that doesn't factor in the ongoing retirement. So it suggests that only 21 appointments have been made, and that couldn't be further from the truth. Then he quotes this article written by this civil litigator in Toronto. I was a civil litigator in Toronto. And then he goes on to talk about the blame being because of lack of courtrooms. Lawyers who practice in the Superior Court know that the only component of the system that falls on the federal government is the appointment of the judges. The lack of courtrooms, when you walk into a Superior Court courtroom in the province of Ontario, the person you're looking at up on the bench was put there by the federal government, paid by the federal government, Everything else, from the light bulbs to the desks to the staffs to the number of courtrooms, is a responsibility of the provincial government. So it has nothing to do with just judicial vacancies, that reference. I'm sorry. In fact, if you want, look, we all agree on one thing, the importance of making sure that judicial vacancies are filled, making sure that access is available to all parties, whether it's criminal, civil, or family. After we were elected in 2015, we introduced legislation that would actually increase the complement of Superior Court judges. Not decreased, increased. So that creates greater access to the courts. The Jordan decision, which keeps getting thrown around, may I remind people that that's based on a set of facts that started in 2009, ending in 2015. And we use the word like negligence when you're talking about appointing judges. How can you do anything but create fear and confusion in the eyes of the public? Using the Jordan decision as an example of anything to do with this current government is just, it's factually incorrect. I'm sorry. It was based on a decision on facts in the court system under the previous government. If you want to be clear on it, if you want to use it, let's make sure people understand. So one thing we do agree on, as Mr. Brock pointed out, is the current Minister of Justice has done a very good job at making appointments, making them quickly. That's not going to change. We've seen evidence of that today. And my last point is this, subject to anything else I might hear today. With respect to the delay of C40, having this discussion right now is already delaying C40 further, because had we not been dealing with this motion, I suspect by 12:30 today we would have been adjourning the meeting because the bill was passed. So let's get on with it. Thank you.
Thank you very much, Mr. Maloney. I'm now going to call, can I call? I don't have any speakers, so I'm going to call for the vote on the amendment. Merci. Clerk, please.
Alors, sur l'amendement de M. Fortin,
So on the amendment put forward by Mr. Fortin.
No.
Mme Brière,
No.
M. Mendicino,
No.
M. Housefather,
No.
Mme Dillon,
No.
Mme Dillon,
No.
Mr. Moore,
Yes.
Mr. Brock,
Yes.
Mr. Caputo,
Yes.
Mr. Van Popta,
Yes.
Mr. Fortin,
Oui.
Mr. Angus. Nay 6, nay 5. Amendment is defeated.
Amendment is defeated. I'm now going to call a vote on the amendment. I'm sorry, on the main motion. Mr. Clerk, please go ahead.
Yes, thank you, Madam Chair. On Mr. Moore's motion, Mr. Maloney,
No.
Mme Brière,
No.
Mr. Mendicino,
No.
Mr. Housefather,
No.
Mme Dillon,
No.
Mr. Moore,
Yes.
Mr. Brock,
Yes.
Mr. Caputo,
Yes.
Mr. Van Popta,
Yes.
Mr. Fortin,
Oui.
Mr. Angus.
No.
Motion is defeated.
Thank you very much, Mr. Clerk and colleagues. Our motion is defeated. That concludes the business for which we are here in front of you today. I will remind you, on Thursday we will continue, and my expectation based on colleagues' representation here in public is that we will finish C40 on Thursday. Do I have a motion for adjournment for today, Mr. Maloney?
Yes, Madam Chair.
Motion for adjournment. Meeting adjourned. Thank you very much. Bonne journée.